Welcome to Employment Law This Week. I'm George Whipple. Late last month, U.S. Attorney General Pam Bondi released guidance warning federal funding recipients against unlawful discrimination in the form of unlawful DEI. Epstein Becker Green's Lori Rasnick breaks down the guidance, who it applies to, hint, it's not just federal contractors, and how employers should respond. Lori shares some examples of unlawful discrimination included in the guidance.
One of those examples is race-based scholarships or programs. This would include race-based internships, mentorships, leadership initiatives, or other programs that reserve spots for specific racial or other protected classes or groups. Another example is preferential hirings or promotions. So any DEI or other policies that prioritize candidates from underrepresented groups for either hiring or promotions would be considered illegal. Another illegal action identified by the guidance is the failure to maintain sex-separated intimate spaces.
An additional example of unlawful DEI is intentionally using neutral criteria that function as a substitute for protected characteristics. This would include recruiting from specific geographic locations or institutions because of their racial or other composition. So what does this mean for employers?
The guidance is not legally binding and does not change Title VII or other laws. The guidance underscores that what the administration perceives as unlawful DEI initiatives continues to be a priority. Even programs that appear to be permissible can be implemented in a manner that runs afoul of the law and could be subject to enforcement risk. For federal fund recipients, unlawful discrimination may result in revocation of their contracts or funding. Another consequence could come in the form of a False Claims Act claim.
The guidance addresses federal funding recipients directly, but it includes a warning to all employers.
While the memo is directed at entities receiving federal funding, it specifically states that other entities subject to federal anti-discrimination laws, including private employers, should review the guidance carefully to ensure their programs comply with their legal obligations. The guidance provides 9 best practices. 1, ensuring inclusive environments. This includes all workplace programs and resources and activities open to employees. 2, focusing on skills and qualifications for employment and other selection decisions. Trying to assess specific skills rather than looking at criteria like socioeconomic status, first generation, or geographic diversity. 3, prohibiting demographic-driven criteria for participation or eligibility. So discontinuing the use of programs or criteria, even if using neutral terms, if they are designed to achieve specific outcomes based on protected status.
Thanks, Lori. Additional best practices include eliminating diversity quotas, avoiding exclusionary training programs, and including non-discrimination clauses in contracts. Thank you very much for watching, and we'll see you next time.